Welcome to The Explainer. You know, it is absolutely wild to think about, but today we are diving into the 800-year evolution of the rule of law. We're going to uncover exactly how it grew to dictate pretty much every aspect of our modern lives. It's like this giant historical puzzle. We'll trace how the law transformed from a basic medieval peace treaty into this massive, sprawling system that regulates the world we live in today. Let's get into it. Here is our roadmap for the journey. We'll start with the roots of the law, then explore law's expanding empire, examine the Human Rights Act, look at the role of the Supreme Court, and wrap up with the common law net. All right, part 1. Roots of the law and its honestly pretty messy origins. So Magna Carta. When we think about it, we usually picture this perfect, triumphant birth of democracy, right? Well, the reality was way more pragmatic. It was a really messy attempt to put a leash on a very energetic, very powerful King John. And it definitely wasn't a one-and-done deal. Sure, it was sealed in 1215, but get this. It was annulled by Pope Innocent III just months later. No way it was going to be that easy. It took years of civil war, a reissue by the regent William Marshall in 1216, and then finally being formalized by Henry III in 1225, basically in exchange for a cut of the taxes. That's what it took for it to actually stick. As brilliant legal minds like Lady Hale and Lord Bingham point out, we kind of get our history wrong a lot of the time. The myth is that the Magna Carta magically, instantly created trial by jury and habeas corpus. But in reality, it didn't do either of those things right off the bat. What it did do, which was an absolute game changer, was put a hard stop on the king's arbitrary executive power. It established this totally radical idea that, hey, even the king is subject to the law. Just listen to the actual words from chapters 39 and 40. Quote, "No freeman shall be seized or imprisoned, except by the lawful judgment of his equals or by the law of the land. To no one will we sell, to no one deny or delay right or justice." I mean, wow. This specific text is literally the bedrock of due process. It is the DNA you find centuries later in the U.S. Constitution and in all of our modern international human rights. And so, those medieval chapters organically evolved into what Lord Bingham calls the 8 defining pillars of the modern democratic rule of law. We're talking about a comprehensive framework here, from the law needing to be accessible and clear, to applying equally to absolutely everyone, having fair trials, and protecting fundamental human rights. It's the whole shebang that separates a society ruled by laws from a society ruled by just brute force. Moving on to part 2, law's expanding empire. The shift from restraining the state to regulating the individual. Okay, let me throw a number at you. 700. As Jonathan Sumption points out, 700 is the staggering amount of brand new criminal offenses created in the UK in just a single year, ending in May 2010. And no, these weren't your traditional crimes. The vast majority of these were born straight out of government regulation. When you compare the old law to modern law, the shift is pretty profound. Historically, the state was super minimal. The law mostly just dealt with regulating property, enforcing contracts, and making sure people weren't arbitrarily injured. But today, the reality is entirely different. The law literally penetrates our families, our workplaces, and even our personal morality. We increasingly use the law to dictate risk aversion and guarantee total security in our daily lives. The tragic Charlie Gard case is a heartbreaking but perfect example of this modern tension. You had clinicians advising that treatment for a severely ill child should be withdrawn, but rather than just making that clinical call, they sought legal backing, essentially absolution from a judge. Meanwhile, the parents raised their own funds for an untested treatment abroad. So what happens? The court stepped in and basically nationalized that incredibly personal parental choice, ruling on the child's objective welfare. A few decades ago, this agonizing moral dilemma might have just been handled privately in a hospital room. Today, society looks to the law to impose a uniform solution. All right, Section 3, the Human Rights Act and bringing rights home. So, how does this actually work in practice? Well, back in the year 2000, the UK's Human Rights Act came into force. This act put all public authorities under a strict duty to respect 16 fundamental rights from the European Convention of Human Rights. This was a massive deal. It meant citizens no longer had to endure the insane cost and delay of dragging their case all the way to the European Court in Strasbourg. It made the protection of fundamental human rights an everyday, domestic legal matter. Now, you might be wondering how the UK model compares to the US here. It's a really fascinating mechanical difference. In the US, they have an entrenched written constitution, which means their Supreme Court can literally strike down laws that violate it. The UK doesn't work like that. Over there, Parliament is supreme, so the courts can't just delete primary legislation. Instead, if a law violates human rights, they issue a declaration of incompatibility. It doesn't instantly erase the law, but it flashes a giant, highly visible warning sign to Parliament saying, hey, you need to step up and fix this.
Let's dive into Part 4, the Supreme Court, the ultimate arbiter.
Created in 2009, the UK Supreme Court was set up to separate the highest court of appeal from the legislature, the House of Lords. Think of it as the ultimate referee. Its job is to adjudicate points of law of massive public importance, set binding precedents for all lower courts, and, absolutely crucially, maintain a healthy balance between the branches of government. It's the essential safeguard to ensure the executive and legislative branches don't unlawfully trample on our civil liberties. But how do they interact with the European Court in Strasbourg? It's a really interesting dynamic. Usually, the general rule is that the UK court has to take into account and applies Strasbourg's case law. But there is a rare, super fascinating exception. Sometimes, the UK's Supreme Court will basically say, actually, no, we decline to follow this, and they invite Strasbourg to think again. This happened in cases about hearsay evidence, like Al-Khawaja. It's a true judicial dialogue. The UK Supreme Court isn't just taking orders. They're actively shaping European human rights law. Which brings us to Section 5, the common law net and bridging the gaps in protection. Lord Briggs brings up an incredibly cool insight here. He points out that the common law, the law developed by judges over centuries, is actually our first line of defense. It's the starting point for human rights protection in domestic law. Over the last 25 years, it has soaked up the values of the Human Rights Act like a sponge. In fact, it's so deeply enriched now that even if the act were somehow repealed tomorrow, the common law would still robustly protect those fundamental rights. If you want to see exactly how the common law evolves in real time, look at the concept of misuse of private information. This is a modern civil wrong, or tort, that literally balances a person's reasonable expectation of privacy against a publisher's right to freedom of expression. The common law essentially invented this entirely new protection from scratch, heavily influenced by the exact values of modern human rights legislation. The shift is just wild when you look at two specific cases. Back in 1991, in the Kay versus Robertson case, journalists took photos of a severely injured actor right in his hospital bed, and the courts basically said, sorry, there's no actual privacy law to stop them. Just a massive, gaping hole in protection. But fast forward to 2004, the Campbell versus MGN case involving Naomi Campbell. The common law had evolved. The court established that new tort for misuse of private information, actively closing that gap to protect human dignity. So, here we are at the end of our journey today. We've gone from putting a leash on a medieval king to a system that scrutinizes everything from medical ethics to tabloid photos. Law's empire has undoubtedly expanded to grant us structure and security. But I want to leave you with this huge, provocative question drawn from Jonathan Sumption's analysis. Are we willing to accept less personal choice in exchange for a world with zero risk? It really makes you think about the trade-offs we make every single day to live in this modern empire of law. Thank you so much for joining me for this explainer. I hope you found it as mind-blowing as I did.